Welcome to this afternoon's seminar on challenging cuts. I'm Leonie Hurst. I'm a barrister here at Doughty Street Chambers, and I'm very pleased to be welcoming you to the seminar this afternoon. We've got three excellent panelists who I will introduce you to in a moment. But first of all, I just want to start by saying you should have access to the Q&A button at the bottom of your screens. If you've got any questions arising through the seminar, please do post them there, and then we'll deal with them at the end of the session. And I want to start by also saying that this was when we started thinking about this seminar, this was intended to be a public law seminar on challenging cuts, given the current political environment and the consequences, particularly of the COVID pandemic. And then as we started talking about it, we started to explore putting an Equality Act spin on it, as it were. And our three panelists today are eminently well qualified to talk about this. First of all, we have Oliver Carter from Irwin Mitchell. Oliver is highly experienced in all areas of public law, particularly health and social care. He also leads actions against the police and represents families in inquests. And he has, in the past, led many challenges to government cuts on behalf of individuals, charities, and campaign groups. He's a former co-chair of the Young Legal Aid Lawyers, and in 2019 received a special award for an exceptional contribution to legal aid and access to justice. And he's going to be speaking about practical case building and giving you a kind of toolkit for public lawyers. Next, we have Alice Irving, who's a junior barrister at Doughty Street Chambers. She's a stellar practitioner with a broad-ranging practice in all areas of public law, with a particular emphasis on housing and social welfare law, community care, education and equalities law. And she's been instructed on a number of cases involving disabled individuals and carers. She has a particular interest in equality issues arising in education law and disability. And she's also been involved in challenging discriminatory measures introduced as a result of the COVID-19 pandemic. She acts in all areas of housing law, and she is going to be speaking about potential grounds of challenge using Equality Act grounds, and particularly the PSED, and also talking about using the Human Rights Act and Article 14 to bring discrimination claims. And last but not least, we have Jamie Burton, who's a QC here at Doughty Street. He is a highly experienced public lawyer, and he is the chair of Chambers Health Community Care and Health Team. He's a leading authority, a go-to authority for all questions of health and social care, public law, homelessness, social security and equality law generally in public law. He is a member of the Equality and Human Rights Commission's A panel of counsel, and he also acts for families in inquests and public inquiries. And Jamie's going to be speaking about consultation challenges and challenging cuts on the basis of consultation. So without further ado, I'm going to hand over to Oliver to start us off.
Thank you, Leonie. And we should have the slides now, which Alice is kindly controlling for me. I should say at the outset, I prepared these slides before the news in the last couple of days about the health secretary, or the former health secretary. So apologies that his face is featuring prominently there on the first slide. Of the 6 cases that feature on the opening slide, Alice, if you could just stick with that for a moment, 5 of them have been decided during the pandemic. And I think if there's a single message to take from that, it's that, of course, the law doesn't cease to apply during an emergency. So reflecting on the title of this seminar of Challenging Cuts to Public Service in a Post-COVID World, I think in principle, the way we as lawyers help individuals, campaign groups and charities to challenge cuts to public services in the post-COVID world will be much the same as in the pre-COVID world, and indeed during the current intra-COVID world. So the context of the challenges may change, but public bodies will remain accountable to the law, and it will continue to be possible in the right circumstances to use the law to challenge cuts, decisions and policies which have a negative impact on disadvantaged groups, including those with protected characteristics under the Equality Act. So looking briefly at the current political context, which is my next slide, thanks Alice, the government we have now is adopting a very different tone in its messaging to the coalition government. We've moved from the age of austerity and balancing the books to levelling up and building back better. But it remains to be seen whether outside the response to the pandemic, we'll actually see increased public spending on public services. The talk of levelling up by the government follows a decade in which central government grants to local authorities were cut by £10 billion or 38% in real terms. And the allocation of local authorities within the government's new Levelling Up Fund is the subject of a legal challenge brought by the Good Law Project, which is arguing that the government has given priority to areas of the country represented by Conservatives. So perhaps some areas are more level than others. And that gives rise to the question of whether there's a disconnect between government rhetoric and the reality of continuing austerity in public services. And it seems likely there will continue to be cuts in non-protected government departments and at the local authority level. If the government did want to level up and reduce inequality in the country, it could implement Section 1 of the Equality Act, which is the duty for public sector bodies to have due regard to reducing inequalities of outcome which result from socio-economic disadvantage when creating their policies and making decisions. That provision wasn't commenced by the coalition government, although it was passed in the Equality Act in 2010, although equivalent duties have since been brought into force in Scotland and Wales, with the aim to put tackling inequality at the heart of decision making. And whether the courts may be a background in the culture wars, of course, in recent years, we've seen some high profile litigation, and the government is now considering restrictions to judicial review and reform of the Human Rights Act. We also saw significant cuts to legal aid last decade by the coalition government. So those of us who believe that public bodies should act within the law and be accountable to the courts need to continue to make that case. Which brings me hopefully to my next slide and the first principles of public law as described by Lord Bingham. And if you want to summarise public law in one sentence, I think this is a pretty good effort. So when faced with a situation where we believe a public body may be acting unlawfully in one of these ways, how do we go about challenging it? And that's on the next slide. We start, first we need to identify the source of the injustice. So what is the decision, action or failure to act which causes the injustice we wish to challenge? While the title of this seminar refers to cuts, there are policies and decisions which have the effect of restricting public services, which are not always openly described by the decision maker as cuts. Instead, we may see terms like reorganisation or reconfiguration of services, which may have the effect of a cut. So once we've identified the decision we're concerned with, we need to identify who made the decision or who is responsible for the failure to act. It could be a government minister, a local authority, an NHS trust or CCG, or another person or body exercising a public function. It's then vital to identify when the decision was made, as any claim for judicial review must be brought to the court promptly and in any event within 3 months of the grounds for the claim arising. Now, judicial review is often described as being focused not on the merits of decisions by public bodies, but on the process by which the decision was made. We therefore need to think about how the decision was made. What was the decision-making process? Was there a consultation? If not, should there have been? And Jamie will talk more about that later. Did the decision-maker ask the right questions and obtain the information they needed to make a decision? Did they act within their powers? Did they comply with their duties? And asking how the decision was made will inform how we can consider challenging the decision. How can we argue that the decision or policy is not just unfair, but unlawful? Next slide, please, Alice. So as campaigners and lawyers, we have a number of tools to make those arguments. I won't cover all of this in detail as Alice is going to speak about the Equality Act and Human Rights Act in some cases brought under those acts, and Jamie will talk about consultation duties, but just to say that the Equality Act, of course, contains a number of provisions which may be relevant to challenging cuts to services, including the public sector equality duty in section 149, which requires public bodies to have due regard to the need to eliminate discrimination and advance equality of opportunity between people who share a relevant protected characteristic and people who do not. Less often used in cuts challenges have been the prohibitions on direct discrimination, discrimination arising from disability, and indirect discrimination. as well as the duty to make reasonable adjustments for people with disabilities. And part of the reason for this seminar is, I think, to consider whether that should change and whether those duties should be used more prominently in cuts challenges. We also, of course, have the Human Rights Act, in particular the Article 14 prohibition on discrimination and the traditional common law grounds of judicial review, as well as provisions which are specific to their sectors, such as the Care Act as it relates to adult social care. And international conventions, although unincorporated into UK law, may still be relevant as a guide to interpretation of domestic law if there's a dispute about that. Next slide, please, Alice. So, as well as considering the potential grounds of challenge, we'll need to think about what evidence will help us to demonstrate the discriminatory, disproportionate, or negative impact of the decision. This may, of course, include evidence from the person who plans to bring the case and other people regarding the impact of the decision. Freedom of Information Act requests can be a very useful tool. In one case I made freedom of information requests to every local authority in England in order to obtain evidence about the impact of a particular government policy on people with a protected characteristic. And I kept a spreadsheet of the responses to collate that information. That case didn't actually proceed to a hearing because the government agreed to reverse the policy that we were challenging after we provided evidence to them. You may also, well, you're likely, when you send a pre-action letter, to be asking for information and documents which are relevant to the decision-making process. And if the public body refuses to provide that information or documents, you can make a Part 18 application to the court, either before or during the proceedings for that information. Expert evidence may also be relevant in some cases. It has had a limited role in judicial review, I think, but may help to demonstrate the impact of the decision or policy or expose flaws or deficiencies in the decision-making process. For example, if the public body has proceeded on the basis of inaccurate assumptions or incomplete information. And finally, on this slide, there may be campaign groups, NGOs or charities which have particular expertise, which can either help with witness statements to support the case or by intervening in the case. It's important to note that the Equality Act duties are anticipatory, so the public body decision maker will need to consider the potential impacts of their decision or policy before it is taken. And we as potential challengers to that decision need to ask, did the decision maker ask the right questions and obtain relevant evidence before making the decision? And if we don't think they did, then we try to obtain this evidence for them and put it to them to reconsider and or file it as evidence in our judicial review case against them. And that moves on to the next slide, which is just some practical issues to consider about funding and costs. Of course, one of the most important things if we're planning to take a case to court is to have a means of funding it. Many public interest policy challenges are funded by legal aid on behalf of an affected individual, but if your client isn't financially eligible for legal aid, or if you're acting for a campaign group or charity rather than an individual, you will need to think about alternatives. And crowdfunding has gained increasing prominence in recent years and may be an option in cases with a particular public or community interest. The Equality and Human Rights Commission may offer support to discrimination cases which fall within its strategic interests, and private funding is of course an option for individuals and organisations which can afford it, and they'll have to be aware of the potential adverse cost risk that if the case goes to court and isn't successful, they may have to pay the legal costs of the public body which is defending the case. And one guard against that possibility or way of restricting that potential liability is cost capping orders, which are available in public interest proceedings. So where the subject of the case is of general public importance, cost capping orders can be used to limit the potential adverse cost liability of a claimant if their case is unsuccessful. The next slide just summarises the judicial review process very briefly. Could do a whole seminar on this, but time won't permit that. So this just sets it out very briefly that in the pre-action stage, you have correspondence to notify the public body of the proposed case against it and the grounds of challenge. The public body has an opportunity to respond, usually within 14 days. And if the dispute isn't resolved at that pre-action stage, you then move on to applying for permission to bring judicial review proceedings. And then if permission is granted, so if the court agrees that you have an arguable case for judicial review, then you move on to the substantive hearing of the case. I think that's all I need to say about that slide before just moving on to some recent success stories, which some of these I know will be covered in a bit more detail by Alice and Jamie, so I'll just skim over them quite briefly. Not all of these are challenges to cuts per se, but they do relate to decisions or policies which had an allegedly negative impact on particular groups. So the Article 39 case against the Secretary of State for Education concerned the temporary downgrading of children's social care duties during the pandemic, and was brought by Article 39, a children's rights charity, which argued that the Secretary of State for Education acted unlawfully in failing to consult bodies representing children in care, including the Children's Commissioner, before bringing in the legislation which made these changes. The case was dismissed by the High Court, but was successful on appeal, with the Court of Appeal holding that there was nothing about the circumstances in March 2020 to justify the Secretary of State's decision to exclude the Children's Commissioner and other bodies representing the rights of children in care from the rapid informal consultation which he did undertake with local authorities and other providers of care. The second case, Bridges, I won't talk about in detail due to time constraints. That concerned automated facial recognition technology and the public sector equality duty. And you'll see that the Court of Appeal found that South Wales Police had failed to comply with the public sector equality duty because it hadn't sought to satisfy itself either directly or by way of independent verification that the automated facial recognition software didn't have an unacceptable bias on the grounds of race or sex. On to the next slide, we've got a couple more. I know Alice is going to talk about SH, so I won't say anything about that for now. DMA against Secretary of State for the Home Department concerned three, I think, people whose claims for asylum had been rejected but were awaiting reconsideration. And those people had no right to work, no recourse to public funds, and the Home Secretary had accepted that she had a duty to provide accommodation to them under the Immigration and Asylum Act 1999, and the claim for judicial review concerned what were found to be unreasonable delays in providing that accommodation and a failure to monitor the provision of accommodation to disabled people falling within that category of destitute, refused asylum seekers. In that case, it's just worth mentioning that the claimants and the court had assistance from evidence from 4 NGOs, including Refugee Council, Freedom from Torture, the Helen Bamber Foundation, and Bristol Refugee Rights, which highlighted the ways in which the needs of disabled people weren't being adequately addressed. So in that case, in addition to a breach of Article 3 of the European Convention on Human Rights, the court found breaches of the Equality Act provisions, Section 15, discrimination arising from disability, a failure to make reasonable adjustments contrary to Section 20, and a breach of the public sector equality duty. Now, my third slide about success stories. Noor concerned Birmingham City Council's housing allocation policy, as it says there, which was found to indirectly discriminate against disabled households because of the particular disadvantage it put them at in bidding for properties. And the court also found that Birmingham had failed to make reasonable adjustments to ameliorate the disadvantage suffered by disabled people under its policy. There was an argument in that case about the public sector equality duty, but the court didn't consider that as it wasn't formally pleaded in the statement of facts and grounds. But the court did say that the council's failure to review the operation of its policy and how it affected people with protected characteristics is likely to have breached the public sector equality duty if it had been pleaded. And the final case there is a challenge to the downgrading of an A&E department at Grantham Hospital. An example of a sector-specific provision of Section 242 of the NHS Act, which is the patient involvement duty. And in this case, the court found there'd been a wholesale failure to comply with the obligation to secure service user involvement in the development and consideration of the proposal. And the court said that the present case illustrates how failure to involve service users in decision-making will foster a sense of injustice, or worse still, undermine confidence in the good faith of the decision-maker. So those are the cases, all successful, good news stories that I wanted to highlight. My final slide just considers some cases and issues which may be before the courts in the coming months. I I won't talk about them in detail. I think they probably speak for themselves. Most people, I think, will be aware of the Universal Credit Employment and Support Allowance challenge to the uplift for universal credit not being extended to legacy benefits. And I think there are around 2 million people potentially affected by that, missing out on £1,040 per year. I think Jamie might be involved in that case, which I understand has been granted permission. I mentioned the Good Law Project challenge to the Levelling Up Fund, and I expect everyone watching will be able to think of other issues and policy areas at a national and local level, which may give rise to future legal challenges. So hopefully the message to take from this seminar is that cuts decisions and policies which have a negative impact on disadvantaged groups can be challenged in court. But of course, you do need to act promptly to take advice and build your case. Thanks very much.
Thank you, Oliver. That was extremely useful. And now I'm going to pass over to Alice.
Fantastic. Thank you, Leonie. So I'm just going to be trying to drive my slides at the same time as talking, so bear with me. I'm doing sort of a bit more of an in-depth dive into a few key cases in the last few years where there have been successful challenges to either things that are branded expressly as cuts or changes in policy which have an effect which is disadvantageous to people. So I'm expecting that, as Oliver drew out at the beginning, that it might be that the government isn't talking so much in terms of explicit cuts, but that we see a lot of sort of shifting of boundaries in terms of eligibility for certain support and so forth, that in practice exclude people from provision. And it might be that those are the kind of cases that we see more and more of. So the first decision I'm going to consider, however, is a case where it was an express cut, and that challenge was successful. So that's the D18 West Berkshire Council case from 2016. And it was a decision of a local authority to cut funding to basically short break provision for disabled children. And it was a very, very significant cut. So this was coming in 2016 at a time when, as I'm sure many of you are unfortunately familiar, there was a significant crisis in terms of local authority funding. And the court was explicit in recognising that at the time that this decision was taken, West Berkshire Council were effectively in a position of having to find around 10 to 19 million pounds of funding in their budget. And therefore the court was very acutely aware of the need to have respect for the decision maker and the difficult merits decisions they were making, but nevertheless the challenge was successful. So this is a great example of a case where you have a successful public sector equality duty challenge. Now, I'm not going to go in any detail into the provisions of section 149 and precisely what makes up the building blocks of public sector equality duty, as we've had other sessions in this series where there has been more detail on that front. But I want to show how it was applied in this case. I want to flag a couple of other things as well. You'll often see the public sector equality duty pled in tandem with Tameside. So in terms of the decision maker needing to make reasonable inquiries to acquaint themselves with the relevant information. And we'll see how that played out in a number of other cases that I'm going to consider as well. But basically that the public sector equality duty includes by implication a requirement that the decision maker makes adequate or reasonable inquiries in order to obtain the information necessary to sort of consider the discriminatory factors under the PSED. The other thing to flag is that there were two other specific provisions that were relevant in this case, although I want to put up a flag of caution. So section 27 of the Children's and Families Act is a duty on local authorities, amongst others, to consider the sufficiency of their provision in meeting the needs of young people in their areas. And it was found in this case that there was a failure to comply with section 27. However, this aspect of the case has subsequently been doubted by the Court of Appeal. So I just want to flag I wouldn't place particular weight on DAT in that regard. And similarly, section 11 you will see pop up quite often in these kind of challenges. And I'm still of the view that section 11 of the Children Act is worth a punt. This is the duty on local authorities and others to make arrangements to ensure that their functions are discharged with regard being had to the need to safeguard and promote the welfare of children. And that's a fairly mouthy duty. And as it sounds, it doesn't have necessarily a lot of teeth, but it's not necessarily harmful when you're pleading a case to pop in that there seems to have been a failure to have regard to those factors in relation to children if the decision impacts on children. And occasionally we do see that that has legs. And here that was another ground on which it was found that the decision was unlawful, was that failure to take into account and promote the welfare of children. But I'm going to focus on the public sector equality duty here. I've got a very brief summary of what that amounts to on the first bullet point, but I'm sure that you're aware that it's a little bit more complicated than that when we actually look at the language of section 149. I've already addressed the fact that it's fairly uncontroversial, completely uncontroversial, that there's a duty of reasonable inquiry placed on local authorities or other decision makers to make inquiries into, for example, whether the decision they're having is going to have a differential impact on people with protected characteristics. But I think it's really important to flag that all of the cases in this area do establish quite clearly that the extent of that duty is going to vary from case to case. And in this regard, the case law around the PSED and inquiry is very similar to Tameside, which is it's very much for a decision maker generally to decide how much they need to find out and where, and it's only when they really egregiously fail to ask the right questions or really carry out the right inquiries that you might be able to latch onto that as a ground of challenge. But they do sometimes fail to do that, and so it's a good option to consider. And at the end there, we have that sort of idea summarised in the context of DAT. So have they taken reasonable steps, and the reasonableness is the standard there, to inquire into the issues in terms of the impact of the decision on those with equality needs, so those with protected characteristics. Now, one of the important things that often happens in these kind of policy level decisions is that the decision maker might be, as here, council members, or it might be in other cases a Secretary of State. They're not necessarily or very unlikely to be privy to all of the information that's been gathered and all of the analysis that's been done, but they're often handed a briefing which contains sort of a breakdown or a summary of what they need to consider and of, for example, any equality impact assessments that have been carried out. And it's legitimate for council members or for Secretary of States to rely on that information, but you're allowed to look at the information they've been given and to query whether or not they've been given the help which they needed. The information that they needed, was it sufficient for them to make the decision in question? So in this case, it was argued on two bases that there were problems. One was that the material provided to decision makers wasn't enough for them to understand the impact on children and parents of cuts to short breaks. This wasn't accepted by the court. There had been consultation carried out prior to the decision making, and they had been provided with a summary of the outcome of that consultation in terms of some of the concerns raised. I think you often find in these kind of documents there might be an element of spin in a particular direction, which might seek to, for example, downplay some of the concerns, but that's probably not going to be sufficient if the broad outline of the issues is set out in the decision-making material, and here that line of argument failed. However, where the case did succeed was that the decision makers were given a précis, effectively, of section 149 and the public sector equality duty, which, as in the sort of quote marks here, was that they need to keep the welfare of service users and the families at the forefront of their mind, particularly those that are at most disadvantaged. And this was the same kind of précis that was repeated throughout a number of documents given to Berkshire Council members, not just in relation to this decision, but in relation to sort of 47 other cuts that they were unfortunately having to consider at the time. And the court criticised this because there was no tailoring of the analysis or the summary of what the duty required to the specific decision. Didn't really capture the full effect of section 149, which is far more detailed in terms of the need to be aware of, discrimination, disparate effects, fostering good relations, the actual content of that duty. And so it was found that here, the paraphrase hadn't been sufficient because it didn't really encapsulate actually what the public sector equality duty meant. So when we went back to the overarching question, that the answer was, well, the members weren't given the help they needed to answer the questions posed. They weren't given an accurate summary of section 149, even though they'd been given the sort of material underlying factual information that would have enabled them to make a decision. And therefore, as a result, there had been a failure to discharge the public sector equality duty in that case, and the decision to cut services was quashed. So it's often the case that you'll have a equality impact assessment or something else in the documentation that's provided, and that might even be produced after you start proceedings. It's can be difficult to challenge those sometimes if they've kind of gone through the motions, but there are things that can be messed up, I guess, by decision makers in terms of whether they've presented enough underlying factual material, whether they've proceeded the public sector equality duty in a way that's careless. So there are angles that are worth taking, and it's really worth thinking quite hard about those documents or the ways in which a defendant is saying they've complied with the public sector equality duty. Okay, so the next decision I'm going to be talking about is more recent, and this is the case of Law Centres Federation and the Chancellor. Again, this is a Public Sector Equality Duty Act, Equality Act challenge, but it's also a more traditional Tameside challenge, which isn't directly tied in with the PSED, so a failure to make sufficient inquiries leading to the overall decision being irrational. Very briefly put, the decision being challenged was an alteration to the housing possession court duty scheme. So this is a scheme that's provided at county courts where a person who is coming in for possession proceedings as a defendant can get on-site free support from a duty lawyer. Those schemes are generally provided by a combination of law centres, not-for-profit organisations and others, and the legal aid agency runs basically tender for the contracts to be those scheme providers. And the decision that had been taken was to change how basically the contracts that were awarded were divided up across the country, so that in previous times there'd been small areas where different providers would win contracts. They were amalgamated into a few larger areas. So you had one duty scheme provider covering a larger area than previously. I think this is a really good example of a circumstance where there's no cut in funding. So the overall kind of spending by the government, it isn't going down here, but the overall effect of the change was having a detrimental effect on people on the ground. And we'll come to that in a second. So basically, the changes were premised on some assumptions that had been made, which were that small schemes in small geographic areas were economically unsustainable. And that's why some contracts had been returned to the legal aid agency and had to go out for re-tender. And so the thought process was, well, if we have a larger contract area, that's more work, that's more income. And so that means that providers will be more competitive, and they will tender for contracts, and they'll be able to hold on to those contracts because they'll be economically viable. So that was very much the case set out in the documentation that went to the decision makers. The difficulty with all of this was this would only really work if the profit you generated in terms of these larger areas was covered the additional costs that you would accrue with having to suddenly service a larger area. For example, additional travel, additional administration, and a bunch of other things that arose. And the fairly damning finding of the court is that there was no evidence that anyone in the legal aid agency who were taking this decision actually thought about the possibility that it might not be that the larger contract areas resulted in an increased income for contract providers. So that was fairly bad. What actually ended up happening on the ground was that a number of law centres that had traditionally provided these kinds of schemes missed out on contracts and or suffered fairly massive decreases in their budget. A knock-on effect of this was that one of the things that those not-for-profit and law centre providers were able to give to clients that they helped when they met them at the court door as a duty scheme advisor was to flag them then on to the law centre or to their organisation and say, hey, we can help you with some of your other issues, including work that fell outside of the scope of legal aid generally. So there was a sort of holistic wraparound service being provided by these particular providers, which then decreased as, say, more commercial firms were winning these contracts and weren't willing to carry out that kind of holistic work. So there was a negative effect on the ground for service users. And so there was a Tameside challenge here about whether or not reasonable steps had been taken by the Chancellor to acquaint himself basically with the relevant information to make the scheme. And again, here are the fairly damning findings of the court. It might have been that the assumptions they made about small schemes not being financially viable were accurate, and that a bigger scheme would have been financially more viable, but nobody seemed to actually carry out any analysis or carry out any investigation on the ground. And therefore, the decision was rational. because the state of the evidence didn't support it and there hadn't been adequate inquiry. So the case was successful on a straightforward tame site analysis. There's also a failure to discharge the public sector equality duty. It was agreed by everyone that the scheme users, so the duty scheme users, disproportionately had protected characteristics. And as I've mentioned, the impact of the decisions meant that those individuals were no longer accessing wraparound or holistic services as easily as possible. And again, effectively, the court said, as we know, that it's not unlawful for them to make a decision that has that impact, but in making a decision, the decision maker at least needs to be aware of the potential effects on people with protected characteristics. And there didn't again seem to be due consideration in this case because there hadn't really been any particular thinking about the fact that this might in fact happen. So we had a successful PSCD challenge here, and again the decision was quashed. And again, just to highlight the importance of these summary documents going to ministers, and again, insufficiently clear in terms of the adverse effects the proposed changes could have on service users. I'm just mindful of time, so I might take the remainder of these cases fairly quickly. We do have the next case, which is Gulu and London Borough of Hillingdon, which I understand actually Jamie was involved in. This is another housing allocation policy case. And in that case, there was a requirement to be able to join the housing register that you had to have lived in the borough continuously for at least 10 years. So again, I think this is another example of, well, there's no express cut in provision here, but there's an exclusionary requirement applied. And this is an interesting case, but because it is a case where we have a straightforward Equality Act kind of core challenge in terms of there being a challenge that this was indirectly discriminatory, rather than say a kind of process challenge focused on the public sector equality duty. There were two appellants by the time that this court case came together. One was an Irish traveller who, because of their nomadic lifestyle, said that this provision disadvantaged them. And the other was a Kurdish refugee of Turkish nationality who had come to be in Hillingdon, having claimed refugee status. And again, because of that background, they hadn't been 10 years in the borough, residing continuously. Again, I'm not going to take you through a crash course in section 19, but it's fairly straightforward in its application to the case once we got our court getting its hands on it, who really understood the provisions. So here, that the policy criterion or practice that was applied was that requirement of 10 years residence in the borough. So that's the first stage of the section 19 indirect discrimination analysis. When it came to the second question of whether it placed people who were Irish travellers as a group or non-UK nationals as a group at a particular disadvantage, when compared with others who didn't share that race, and that was a sort of the expansive reading of race given in the Equality Act, it enabled those two kind of categories to be drawn out. There had been some difficulties at first instance, shall we say, in terms of how the comparison exercise had been carried out. So a really critical thing to think about with section 19 is who is the group that the claimant forms a part of, and who is the group that you're going to be comparing them with. And in here, some of the first instance judges had fallen into error in that regard. Here, we were meant to be looking at the group of people that are Irish travellers and comparing them with non-Irish travellers. And the overall outcome was it's clear that they were relatively disadvantaged because of nomadic lifestyle. In relation to non-UK nationals, again, we were looking at the group of non-UK nationals versus UK nationals. And in those two groups, a higher proportion of non-UK nationals were likely to fail to meet the residence requirement of 10 years because they were less likely to have been in the country even for the last 10 years. And at first instance, the judge had fallen into error in comparing non-UK nationals and UK nationals who had been in borough for, say, 2 years and treating those as the comparators. So it is always worth thinking quite carefully and bouncing around with your legal team the ideas about who the comparator is. And this is a good example of the fact that it's actually often the more obvious and sort of simple analysis that generates the outcome you want. In only one of the cases, in the Gulu case, public sector equality duty have been argued as a separate ground of challenge. But nevertheless, overall, the court considered that it was also relevant to whether or not any indirect discrimination could be justified. And so it's worth drawing out that link. If you're running both a PSED challenge and a Section 19 challenge, they're going to interact, and it's going to be relevant to consider whether a failure to discharge PSED is going to mean that they also can't justify things. A key issue in this case was, well, should they have been able to foresee the fact that there was going to be an impact on these specific fairly niche groups? And the court said you don't have to kind of preview and see everything in advance, but at a later stage when the issue had obviously been raised and somebody had put up their hand and say, hey, how about how this impacted on non-UK nationals or Irish travellers at that point, they should have really been considering that impact because the PSED duty is ongoing. Now, I'm mindful of time. I've just got a reminder, so I'm going to do a whirlwind through this, and then I may hand over without discussion of the final case on my slide. In terms of the justification, we're familiar with justification under indirect discrimination. We've got a proportionality analysis to carry out. The key argument, in fact, that was made by Hillingdon in this case was that there were sort of exceptions to their 10-year residency requirements, and that the overall effect of these safety valves meant that there was not a problem with the scheme. The court rejected this. Effectively, when you have an argument that's made by a local body in this regard in terms of a safety valve, you've got to look at whether that's actually effective and whether it actually eliminates the disadvantage. It's not enough to just say, oh, look, we've gotten some exceptions. And here there was no evidence that the safety valves actually functioned to eliminate the disadvantage to these particular groups. And so that wasn't a sufficient argument, and it was found that the indirect discrimination wasn't justified. The final case I was going to talk about was SH and Norfolk County Council, but I think it might be wise for me at this point, just looking at the time and having gotten very excited about these cases and going into detail, to hand over at this point to Jamie. But very briefly, headline notes, this was effectively a challenge to a change in charging decisions for adult social care. Again, an example where there's not a cut per se, but a change to how things are calculated has a really massive impact on people with severe disabilities. And this was run as an Article 14 challenge, which was successful. And Article 14 is always worth thinking about alongside or instead of the Equality Act in addition. So thank you for bearing with me. And without further ado, I'll hand over to Jamie, who's going to speak specifically about consultation challenges.
Thank you very much, Alice and Oliver. Fantastic talks. As they've intimated, I'm going to say a little bit about consultation challenges. It seemed difficult to have a seminar around potential judicial reviews in the context of cuts to services without looking at consultation, both because, of course, failures to lawfully consult may themselves be the principal grounds of challenge, but also, certainly in my experience, there's a relationship between the extent to which a public authority has properly consulted and explored options, etc., and the sense of trust or security that the court has in the final decision making. And I think both sides know that. You know, if a party is seeking to challenge a decision made, particularly in the context of a cut to a particular service, they may wish to emphasize the lack of any prior proper consultation, the lack of any prior consideration of the PSED obligations, all the indicators that suggest that really the public authority was giving the impression of an open mind, but was in reality fixed upon a particular financial saving, because of course that is a phenomenon that we're probably all familiar with. And doing so, even if you don't win on those challenges, can sometimes help you with other aspects of the challenge, I have found. And similarly, of course, public authorities often wish to demonstrate the copious efforts they've gone to explore alternatives and explore options. And of course, sometimes that's entirely earnest. Sometimes it is slightly less earnest. But either way, they recognise, I think, the same point that I'm trying to stress, which is that the relationship between the the nature and approach towards consultation can have an impact on grounds over and above the strict consultation grounds, as it were. Alice, would you mind changing the slide? I mean, I began with this quote just to really hammer home the point made by Oliver, which is, you know, we need to be realistic here. Even the Financial Times has recognised the obvious, which is before long we are going to see a form of austerity. It may not look and sound exactly like austerity version 1, but it's going to be much the same in terms of its inherent character. And indeed, the point that's made there by Paul Goodman in the Times about Mr. Johnson not being able to evade economic reality forever is not that these cuts are inevitable. It's not that the country cannot afford to meet the services that are necessary to ensure the well-being of the population, but more that the economic realities facing the Conservative Party are such that they can't realistically increase taxes in a way which would lose their voter base, and therefore they're going to have to look to other ways to cope with the burgeoning public debt. And we all know what that means. We know what it meant in 2008, and we're probably right to assume, as Paul Goodman does, that it's going to seem exactly the same probably after the next general election, but we'll wait and see. So on consultation then, first slide, of course, it's not actually correct to say there is always a duty to consult, but as I'm going to show in a moment, I think in the context of cuts to existing services, we're pretty close to that position. There are, of course, often circumstances in which there is a discrete statutory duty to consult in the context of a particular function. I've given 3 examples there. The first concerns NHS and reorganisation of NHS services. I think Oliver already referred to that. The second one from the Health and Social Care Act 2012 deals with CCG, so related to that. And then the Local Government Act 1999, which is the best value duty, is an interesting one. I mentioned it a little bit at the end of my talk this afternoon. If only because it applies to a lot of different public authorities, if they're best value authorities, and does require the particular public authority to examine things like social impact, etc., which can be very relevant in the context of cuts, which may be impacting upon, if you like, the social quality of services that are being provided. But importantly, the obligation to consult often does come from the common law. It comes from the common law duty to act fairly. You know, procedural fairness is a species of the broader duty to act fairly, and that was confirmed in the Mosley case, which, believe it or not, is really the only Supreme Court case on the law of consultation, and you'll have to forgive me for referring to it a number of times in my talk this afternoon. But in Mosley, they confirmed that the common law duty to act fairly may mean in practice that there are at least 2 scenarios in which consultation will be mandatory, even in the absence of a statutory obligation. The first is, you know, consistent with the sort of doctrine of legitimate expectation, that there's been a promise or a representation or an established practice of consulting by the public authority concerned. And the second scenario, which is perhaps particularly relevant in this context, is this principle, namely that the demands of fairness are likely to be somewhat higher when an authority contemplates depriving someone of an existing benefit or advantage than when the claimant is a bare applicant for a future benefit. And that really is the point here, isn't it? I mean, if we're talking about cuts to existing services, then by definition, you're going to have a body of people or organisations who are no longer going to receive something they were previously receiving. And that was the basis for establishing a duty to consult in the Article 39 case that Oliver mentioned previously, and indeed in the KE and Bristol case, which concerned cuts to send provision. So it's always going to be the case, it seems to me, that where you're dealing with a cut, prima facie, you're probably looking at a duty to consult. And importantly, this is a rider on all of this, that public authorities, of course, sometimes choose to consult anyway. But if they do, then the law is very clear that the standards of fairness apply equally, whether or not there's a legal obligation to consult or whether or not it's the exercise of a choice. So who must be consulted? Well, again, statute may specify specific consultees where you have a statutory duty to consult. Often the legislature has in mind the opinion of certain key stakeholders. It might be the police, it might be the NHS, it might be local government, it might be the mayor, etc. But it's very rare to see an exhaustive list. Almost always there is a sort of catch-all rider, such as the 2 examples I've given in the handout there. Such persons as it considers are likely to have an interest in X whatever X might be, or whatever community representatives the local authority thinks it's appropriate to consult. So there will be some sort of catch-all duty that applies, and that might give you some basis upon which to assert that a particular interest group, stakeholder or body, beyond those who are directly affected perhaps by the measure, might have been properly consulted. The identity of the consultees may also be informed by the same duty of fairness, which will be linked to the purposes of the consultation. And there are some purposes which are ubiquitous. They apply really to all consultations, albeit with a greater or lesser degree of emphasis. And that again was confirmed in the Moseley decision. And the three purposes identified there were the first one, that of course public authorities are liable to make better decisions if they have properly taken into account the views of others, particularly those who are likely to be directly affected, and properly tested their preliminary views in that context. The second is to avoid a sense of injustice which the person who is the subject matter of the decision will otherwise feel. Well, of course, we can see another close correlation there between that principle and the one I mentioned a moment ago about the duty to consult in the context of people who are likely to be deprived of an existing benefit. And then this final one is interesting. It was particularly interesting in the Moseley case, and it's about this democratic principle of participation. It's about ensuring that public authorities make decisions that, are in accordance with, the not necessarily majoritarian opinion, but at least reflect opinion in their local area, and in such ways it can be demonstrated that the particular public authority was concerned to ensure that their primary duty to uphold the principle of democracy fundamentally was reflected in the manner in which they went about their consultation. And there you can see why issues around the sort of extent to which it's a bona fide consultation, it's not just a tick box exercise, it's actually designed to try and ensure people are given the best possible opportunity to contribute and participate, etc., will be a reflection of that particular purpose, if not all three of those purposes. But beyond that, of course, you won't be surprised to hear that it's ultimately for the public authority to decide, subject to normal public law principles, who they choose to consult in respect of a particular consultation. Again, method of consulting, very similar type of analysis. The statute itself may specify a particular method. The 2014 Antisocial Behaviour Act specifies exactly how a draft public spaces protection order ought to be published, the means and how and for how long, in order to ensure proper consultation. But beyond that, there's a very broad discretion. Fairness may again have something to say about that. The purposes of the consultation in Moseley, that was particularly relevant. It was a consultation in that case about a cut to a benefit that would be that would impact those on the lowest income in the London Borough of Haringey, and the court basically said that it was appropriate and would not otherwise have been appropriate if they hadn't done what they did, which was to send individual letters to all of the people who are going to be affected by this benefit cut and invited them personally to contribute to the particular consultation. And then the overall circumstances may well be relevant to the method of consulting, and we saw that in the Article 39 case. Oliver referred to it a moment ago. The court took cognizance of the fact that we were in the midst of a pandemic. We were quite early on in that, and what the government was ostensibly trying to do was to reduce the burden on decision makers in the childcare context. And they understood that, and they understood that that justified a short form version of consultation. Where the court disagreed with the Secretary of State in that case was the one-sided nature of the consultation, of course, because if it was appropriate to have any kind of consultation, then it was appropriate to consult everybody who was an appropriate consultee, and that included people who would be less, more on the side perhaps of the children going to be directly affected by these services rather than the service providers themselves. But discrimination is certainly very relevant here. So discrimination isn't only relevant, of course, to the ultimate decision that's under issue and whether or not it has adverse impacts on people who share protected characteristics, but discrimination arguments can also be relevant to the question of how the consultation is actually carried out. Because of course a consultation, to be a lawful one, must be one which is effective and must ensure effective participation from consultees, and that may require reasonable adjustments to be made, for example, about how documentation is to be received, responded to, opinions to be canvassed, etc. So it's always worth looking out for those particular issues in the context of a particular consultation that's taken place. So what's required of a lawful consultation? Well, here we have the classic Sedley Principles, often called the Gunning Principles, sometimes even called the Cochrane Principles, and even now finally sometimes called the Moseley Principles. But the principles thankfully have stayed the same, even if they've been called something else. Now, there are 4 aspects to this. The first is that the consultation must be at a time when proposals are still at a formative stage. The second is that the public authority must give sufficient reasons for any proposal to permit of intelligent consideration and response by consultees. The third, that there should be adequate time to ensure the consultees have the opportunity to consider it properly. And then finally, there's obviously the need to ensure conscientious consideration of consultation responses. And in Moseley, an expression that those 4 limbs or those 4 principles were a prescription for fairness was endorsed. And of course, it's important to understand that because they're not inflexible. Rules here, what these are manifestations of the broader principle, which is consultations must of course be fair. So just looking at all those 4 individually swiftly, and the first, the consultation must be at a time when proposal is still at a formative stage. So this is actually quite difficult often in some cases. I mean, what is the particular proposal? You know, when can one say it's necessarily at a formative stage? How far back do you need to go, particularly in the context of cuts, for example? Would you need to go back to the budget setting, you know, at the beginning of the financial year and say, well, that's basically when this policy was formulated, because everything thereafter was somewhat inevitable? It's very hard to come up with a single way of trying to test that in a particular case. You know, it's a judgment to be reached by those who are proposing a challenge. One question I think is quite useful to ask is this: you know, is the consultation about whether a particular proposal will be implemented, or is it really about how a particular proposal will be implemented? And if it's the latter, then at least it's arguable that there is consultation is taking place too late. How the courts will go about judging this question is by looking at it objectively. It's very or very similar to the kind of bias test. It's of course very hard to prove that decision makers have in fact made up their mind. What you look for are facts which would suggest that a neutral observer would take the view that there's a real risk that they have in fact basically made their mind up, or at least closed their mind to alternatives. But this is a difficult principle upon which to bring a challenge, really because of the point that was made by, I think, Mr. Justice Dove in the electronic collar case, which was that if you're going to say, and the law does say this, that it's legitimate for a public authority to consult just on a single option, you know, having decided that it thinks there's one favoured solution to a particular problem, then that's going to look an awful lot like predisposition towards a particular solution. But that wasn't to be mistaken for predetermination. And it's only in the context of predetermination that one can seriously suggest that the first principle, or the first Sedley principle, has not been complied with. So challenges under principle 1 are very difficult. On the other hand, challenges under principle 2 do tend to be the main battleground in the context of consultation challenges. So I'm going to say a little bit about this. First of all, we have the classic statement from the Cochrane case, which is that the obligation is to let those who have a potential interest in the subject matter know in clear terms what the proposal is and exactly why it is under positive consideration, telling them enough, which may be a good deal, to enable them to make an intelligent response. The obligation, although it may be quite onerous, goes no further than this. If you wouldn't mind telling the slide, Alice, thank you. So what does that mean in practice? Well, it certainly means there's a duty to be candid on the part of decision makers, but that's not the same as saying that they have an obligation to be completely neutral. They're not supposed to, or they're not necessarily obliged, I should say, to summarize the arguments against their preferred option. They can simply present their preferred option and the reasons why they're preferring it, and that may in certain cases be enough. In terms of the information that needs to be provided to consultees, well, the mere fact that some information is significant doesn't necessarily mean it needs to be provided to consultees. It's a question of degree. Just how important is it? And in the ISI case, it was found that the degree of significance wasn't enough. It wasn't a highly material factor that was going to influence the consultation. And you can see immediately that there's a great deal of scope for argument about that. I mean, what do consultees really need to know in order to really, dig down into the proposal and say something intelligent about it so as to be of use to the public authority so as to uphold those three core purposes of the consultation, making sure they feel that they've been properly consulted, even if it's a benefit that it's a concern to benefit that they're losing, and also that the principle of democratic participation is upheld. And then finally, of course, that the decision maker is best equipped to make a good decision. And the Law Society versus the Lord Chancellor case is an example of where the court found that the absence of certain information was actually so important as to vitiate the entire consultation. I'm sure that had nothing to do with the fact that that consultation was about how much barristers should be getting paid for certain high value cases. So this is a real battleground. And one important principle that came out of the Moseley case, or one important sort of point of analysis, at least, that came out of the Moseley case, is that the degree of specificity in the consultation documents may in fact be influenced by the nature of the consultees themselves. Now, the facts in that case, very, very briefly, were that Haringey Council were faced with a dilemma. They had to make a cost saving in order to finance their council tax reduction scheme. The council tax and reduction scheme had replaced a national benefit called the council tax benefit. But the government at the time, the coalition government, said to local authorities, well, we want you to run your own version now of council tax benefit, but we're going to give you slightly less money than we used to give you when this was a national benefit, all be administered by local authorities. So local authorities were faced with a dilemma. How did they claw back that money? And one way of doing it was saying to those who had previously not paid any of their council tax, i.e. they'd had a full rebate, that they should pay a percentage of their council tax. And that ranged from local authorities imposing a 0% and other local authorities imposing 20%. The problem that Haringey had was that in their consultation documents, they simply drew a straight line between, on the one hand, the government saying the law is now changing, you've got to have your own council tax reduction scheme, and consulting on the idea of taking money back, or another way of looking at charging people for the first time a percentage of their council tax. What they didn't say or explain in their in their consultation documentation is that they'd already ruled out certain other alternatives, like increasing the amount of council tax they received overall to try and make up the shortfall that way, or cutting other costs, like costs that were being incurred by Haringey and its services, or in terms of the levels of employment and pay and remuneration that people were receiving in the council, etc. None of these considerations were made clear to consultees, and the court ultimately concluded, and it's the last paragraph there, that fairness demanded that in the consultation document, brief reference should be made to other ways of absorbing the shortfall and to the reasons why Haringey had concluded that they were unacceptable. So if we could just turn over. And the argument was raised but rejected in the Supreme Court, although it had been successful in the Court of Appeal, that it wasn't necessary for Haringey to say anything about, for example, why they weren't prepared to increase council tax, because it would have been obvious to the consultees why that wasn't plausible. And the actual reason was because Haringey would have had to have carried out a separate referendum on that issue. And the Supreme Court rejected that idea and said, well, that didn't make any sense. There was no reason to assume that the most economically disadvantaged in the borough, or particular ordinary members of the public, would have known about that particular feature of council tax and the need for a referendum. And the fact that a particular, or a handful really, of consultees had understood that position didn't undermine that finding that essentially the consultation was unfair because it hadn't referred to those alternatives. Another case, AA versus Rotherham, looked at the matter slightly differently and said, well, although there were arguable flaws in the consultation document in the sense that they didn't allude to alternatives that had been rejected, that didn't matter because consultees did in fact understand the true position, because the particular consultation that was challenged was one of a sequence of consultations, and it could be assumed that consultees who'd been involved in the prior consultations had properly understood the true position by the time they got to the relevant consultation. So does that mean we now have a new principle that it's always necessary to consult consultees about alternative options? Well, what was said by the Supreme Court was that sometimes fairness will require that interested persons be consulted not only upon the preferred option, but also upon arguable yet discarded alternative options. And some cases were referred to in support of that proposition, but very little explanation was given about when those sometimes circumstances would arise. But there was also a proviso, an important one that was actually applied as part of the ratio of that case, which said that even when the subject of the requisite consultation is limited to the preferred option, fairness may nevertheless require passing reference to be made to arguable yet discarded alternative options. And have the courts adopted that since? Well, it's a bit of a mixed picture. I mean, what the courts have certainly said, and this is the Court of Appeal and the High Court, is, well, essentially, Moseley didn't set a new principle or an invariable rule, but it does seem to me that it will still be necessary in most cases to say something about the other options that have been discarded, if any kind of intelligent response can be made to the preferred option. And you can see very quickly in the context of cut cases why that could be very important, particularly if you're looking at a scenario such as was referred to by both Oliver and Alice, where you've got a kind of disguised cut, where the public authority doesn't really want to be completely out in the open about its decision making. And if they're required actually to say what they were thinking about doing instead of what they're proposing, that can make it more difficult for the public authority to keep its sort of true motives or hopes or aspirations for a particular policy hidden. What is clear, however, is that only realistic options must be consulted upon. And just I'm going to move quickly now because I've been given a time warning necessarily, is of course all of this falls within the general concept of fairness, which is a protean concept. It's malleable and doesn't really give rise to fixed mechanistic approaches to consultation. The third principle is adequate time. I'm not going to say very much about that. We've got sort of one case on it that said 11 days is not enough. That's the Port Louis case. What was said in that case, however, is that the court may judge whether or not there was sufficient time based on whether or not any of the consultees asked for more time. So if you're advising some people involved in a consultation and you don't have enough time, make sure you ask for some more time if you want to criticise consultation response at the end of the process. Next slide, Alice, please. The fourth principle, again, very difficult. Can you prove that there wasn't conscientious consideration given to the consultation responses? It is possible to win on this, though, but in one way, which is to pay very close attention to any summaries or officers' reports which seek to inform the ultimate decision makers about the product of the consultation. And what one often sees is a summary report and then right down in the exhibits somewhere the actual consultation document. And those summaries can sometimes be a bit misleading. And that's certainly one way in which you can sometimes challenge on the fourth principle. And I've given two examples of that, the Cathco and the Kohler case. The Kohler case was also quite interesting because it was clearly shown that the Mayor's office hadn't in that case considered at all a submission from one particular consultee, which had real traction and suggested that the consultation was premature because further research had to be undertaken before a proper decision could be made. But generally speaking, it is quite hard to bring challenges on those principles, on the fourth principle, sorry, but you should always be looking. So really speeding along now, there is always this issue about reconsultation. What if the public authority basically comes up with a completely different proposal and then adopts it after the consultation, one which is materially different from the one they consulted upon, but doesn't look like the natural product of the consultation exercise itself? Well, in those circumstances, it is possible to establish unlawfulness if you can show that there is some fundamental difference between the proposal consulted upon and the ultimate one adopted. And I've given you two examples of cases there, one going one way and one going the other way. And then just finally, this is just a slide really just to point to some interesting provisions which may feed into the consultation process. PSED, we've already heard about that, particularly interested in the interaction between PSED and formative stage and how that works on consultations. Section 1C of the NHS Act, if you're looking at something concerning NHS reorganisation, there is a duty there to have regard to the need to reduce inequalities between the people of England with respect to the benefits that they can obtain from the health service. That is not really a duty that anybody's looked at very much. There's only really one case on it. It was rejected in that case, and it was partly rejected because the proposal to close or consolidate pharmacies both impacted people in low income areas, but also areas, more rural areas, and there was a kind of trade-off between those two, and there was found to be no breach of Section 1C, but it's always something worth looking at. There's the best value duty, which I spoke about a little while ago. It's somewhat anachronistic now. It was something that was sort of introduced by New Labour, but it's this idea that public authorities should be taking the longer term view about service provision, and that may sometimes, for example, require them to adopt the not necessarily the least costly option. It may require them to look at more expensive options if it's more sustainable, and that can be something that can be very valuable as a form of analysis for cuts cases. Same with the Public Services Social Value Act 2012, which is about procurement. A lot of these cuts cases are about procurement of services, and there is a clear duty there on public authorities to ensure that they consider how service provision might improve the economic, social, and environmental well-being of the relevant area. And the emphasis there is on the social in particular. You know, are local authorities or other public authorities selecting the cheapest option and overlooking options which might have more wider social impact, and in the context of austerity and fiscal difficulties, that type of issue can be highly material. And finally, the community right to challenge, which some of you may be aware of, which gives community groups the right to express an interest in taking over a service that might otherwise be facing closure or re-procurement to a service provider who's going to provide it for much less and therefore provide a thinner, less effective service. And a community group may be able to say, well, we'll do it on a not-for-profit basis and you can make your financial savings that way. So that's something interesting to think about in the context of cuts challenges too. Thank you very much. Sorry to speed through that quite so quickly. It's probably a seminar in each of our talks individually. So hopefully we've still got enough time for questions.
Thank you very much to all three of our panelists. Has anyone got any questions? There's no questions in the Q&A, but if anyone has any, can you post them in the Q&A? And in the meantime, I have a general question for all three of you, which is, obviously you've looked through the various talks at various areas where these challenges will arise, and I wondered what you thought would be the most likely areas for forthcoming challenges as we move out of, or hopefully move out of, pandemic.
Goodness me, I'll pitch in immediately with, in my sort of areas of natural interest. We've obviously got decision making being made on adult social care and how that's going to be charged for going forwards. They keep promising it, but you know, eventually they will make a decision on that, and I imagine that's going to be deeply controversial. We also have the SEN review and the review of the national trial in the SEN tribunal, for those of you familiar with that framework. And again, I think there are going to be fairly considerable questions about any changes to the provision of EHCP plans to young people and children, and any change to the national trial jurisdiction, whether or not the SEN tribunal can continue to hear health and social care matters.
Oliver, Jamie?
I mean, I would say that internally the NHS is going to have to make cuts through the kind of process of reorganisation. I think that's inevitable. You know, there's just no way of squaring that circle. Central government is going to suggest that they're still increasing the amount of money that's going to the NHS. But, you know, as the demands on the NHS increase, it's not going to be possible to meet that without real-time increases in NHS funding, which aren't coming anytime soon. And then the simple answer to your question, which is a really good one actually, is where they think there's going to be least resistance. And that is exactly where they're going to go for. So legal aid is one. And they're definitely, I think, going to make further cuts to legal aid if we're not careful, because we keep on doing the work. And you can see other similar patterns in other places. I think there may be limits to how much further they can really cut local authorities savagely, just because they've been cut so badly thus far that most of them are already now down to core statutory services rather than discretionary services. But you never know. And, you know, local authorities, there's a real political dynamic there, because, of course, a lot of them are run by councils which are Labour, and therefore, you know, a Tory government is quite happy to pass the problem on to them.
Oliver?
Yeah, I think just following on from that, we may see the ongoing impact of cuts that have already been made over the last decade or so, particularly at local authority level. So that reduction from the central government grant that I talked about. Sorry, is my camera on or off?
On.
On. Okay, good. And I mean, the departments, the government departments, which traditionally field the largest number of judicial reviews, I think are the Home Office, the Department for Work and Pensions, and the Ministry of Justice. And I suspect that will continue, but there'll be cuts in other areas too, and challenges in other areas, particularly maybe environmental litigation will come to the fore. And I agree with Alice, of course, about adult social care being a particular area of concern.
Yeah. And what impact do you all think that the consultation that's currently running on judicial review and also on the Human Rights Act is going to impact on? Obviously, access to justice is a major issue in bringing these kinds of cases. Are we going to be able to do it in the future? $1 million question. There you go.
I mean, my optimistic view is on the HRA consultation, I don't think that is going to have a major impact. I mean, there are two things they're specifically looking at that might be relevant. One, the extent to which you need to have regard to, you know, Strasbourg decisions. I don't think we're going to see much more than really a restatement of the existing law, perhaps with a slight change in emphasis. And then they're also looking at the relationship between the court and kind of democratically elected decision makers. But things can't get much worse than manifesting without reasonable foundation, which is the current test. So, you know, I don't think that's going to get any better, but I'm not sure it's going to get much worse. Although there is, you know, this tension at the moment between Strasbourg and the Supreme Court on that precise issue, which is yet to be resolved, and we will need a case which deals with that soon enough. In terms of the judicial review one, I mean, that is more pernicious in other ways, which have more general application about the extent to which we can actually obtain effective remedies. But you know, I can't immediately think of a reason why that will be specifically bad for challenges to cuts. But you know, it would make sense if ultimately it was bad for these types of challenges, in the same way it may well be bad for lots of others too. But yeah, I mean, none of it's positive in that sense.
I guess I might have some concerns about the sort of the future of crowdfunding for some of the campaign sort of groups that are able to bring judicial reviews at present, where it can be difficult sometimes to find a legally aided individual client, or there are other reasons why you might want, say, someone like Article 39 to bring a challenge. And if there are restraints, there have sort of been rumblings about that in relation to, for example, standing or any issues around crowdfunding. I think that will make it far less feasible for some of the important claims to be brought.
Yeah, I agree with all of that. And on judicial review, as Jamie said, really the target of the government's current proposals seems to be remedies and the proposals to introduce either suspended quashing orders or prospective only remedies as tools that the courts can use. And I think much depends on, firstly, whether the government does go ahead with that proposal, and secondly, what latitude and discretion the court retains to decide on the appropriate remedy in the cases that come before it. And I think the courts will be quite reluctant, or most judges will be quite reluctant, not to grant claimants who have brought successful cases a remedy to that injustice. But no doubt some judges will use additional powers that the government gives it.
Okay, we've got a question from Sasha Rosansky, who asks, I think this is one for you, Jamie, why do you think there haven't been many cases under Section 1C of the NHS Act?
I think there are probably two reasons for that. The first is, you know, free at the point of delivery may make it less immediately obvious why a decision in relation to the services under the NHS Act is going to have an impact on access in that way. Whereas in fact, I think, as the few cases that have been run under it show, often there are reasons why that's the case, but it requires a bit of analysis that you know, those who are working in this area may not have the expertise to undertake. You know, if you're actually going to look at regional disparities and certain, you know, the provision of certain services, certain operations, or certain primary care services, etc., you know, that's quite a big undertaking. And two, I think, you know, it's probably a reflection of the fact that you don't actually get all that many challenges to NHS reorganisations generally, because they're really difficult and they're very complicated, and very few people are doing them. But I'm personally absolutely convinced there's going to be lots of them. I've already made that point in the next sort of 3 to 5 years, if not sooner, because there just have to be. I mean, there's no other way of squaring that particular circle. And I think at that point, 1C may become quite relevant. Of course, it is only a due regard duty, but you know, there's still mileage to be had with those, and you know, I think we should be looking closely at it.
Do either of you two want to add? No. Okay. Are there any other questions? No. In that case, I'd like to thank everyone for coming, and to say a big thank you to all three of our panelists for a really detailed and, certainly from my point of view, a very, very constructive way of looking at bringing these kinds of challenges in the future. So thank you very much.
Might I just add one plug for the rest of the seminar series? Some people who are listening to this may or may not have a great deal of experience of bringing challenges under the Equality Act, and may have thought some of this was sort of skirting over the legal principles. that is true, but there are a host of seminars now dealing with the key principles. So if you want to actually understand the Equality Act a bit better, we've got a seminar on indirect discrimination, a seminar on direct discrimination, seminar on disability discrimination, etc. And so this is very much supposed to be part of that series. And so people can, go and look at those different seminars and put them together and, sort of improve their overall knowledge that way. Today's seminar was really about just trying to spark some ideas about how we might challenge or deal with the onslaught that's on our way. So yeah, I just want to make that point.
Yeah, absolutely. And if you do want to do that, all of the recordings and slides are available on Data Street's website. Just go to the events page and then search for Equality Act, and they're all listed there. Great. So thank you very much, everyone, and thank you to our panelists, and goodbye.
Thank you, Leonie.